Okay, good afternoon, ladies and gentlemen. Welcome to the KZN SASLAW Chapter AGM for June 2020. Thank you for taking of your time to be with us this afternoon. We understand that these are challenging times, and so we've had to do things a little differently with the AGM today. Firstly, insofar as the minutes for the last AGM are concerned, we have asked the minutes to be confirmed by email. Shlingiwe Skosana has confirmed the minutes for the last AGM. We'd just like to reiterate that despite the current circumstances with COVID-19, SASLAW and the KZN SASLAW chapter is fully committed to SASLAW. Seminars will continue via MS Teams, Zoom. We will be using platforms to continue to deliver to our members. I'm just going to go through the KZN chapter report, which would have been emailed to you by Diane. I'm on page 1 of the June 2020 report. You will see there that we've just set out the seminars we've held since May 2019 to April 2020. And obviously, in addition to those seminars, we also hosted the national conference last year, and that was a huge success. If you go over the page to our membership, you'll see that we have had an increase in our numbers. In May 2019, we had 147 members. In May 2020, we now have 164 members. Insofar as the pro bono project at the Labour Court is concerned, as at May 2020, and this is from the beginning of 2020, the hours spent in the advice office is 61 hours. Obviously, with the national lockdown, we've had to close the pro bono office. This, however, does not preclude any individuals from approaching the office if need be. We have had challenges in that a lot of the individuals who approach the pro bono office do not have access to email, and therefore we haven't had any queries over email. What we are doing is obviously looking at cases that already have come in and reviewing those cases. Mr. Vilagazi, the registrar at the Durban Labour Court, is also aware that SASLAW remains committed to serving the public, and so he is aware that if any individuals approach the Labour Court, Diane can be contacted for attorneys to assist. Just insofar as the financials are concerned, it's been a good year financially. You will see the membership fees and seminar fees. The total there is 208,004.58 rands. The expenses, which include consulting fees, printing, prizes, marketing, stationery, seminar costs, telephone and travel, is 151,802.35 rands. Just from my side, I would just like to thank our members who continue to support SASLAW, and we look forward to another successful year and seeing you at our upcoming events and seminars, even though these would be done via social media platforms. As the outgoing president, I would like to extend a personal token of gratitude to Taryn Popesco for all her support in her capacity as Vice President of the chapter, as well as to our KZN Administrator, Diane Cochran, for her consistent and sterling commitment to the chapter. I would also like to thank the committee, which has worked diligently in ensuring our continued growth and success. We welcome some new committee members on board and thank those that are leaving for their support over the past year. Insofar as the KZN Chapter Committee for 2020-2021 is concerned, the President for 2020-2021 is Taryn Popesco, and I'm pleased to announce her as President and confident that she would do a great job as President of the KZN Chapter. Insofar as the actual committee members were concerned, there were just enough nominations, so we do not need to put that to a vote. Insofar as Vice President was concerned, however, there were 2 nominations. myself and Shlingiwe Skosana. You would have received an email, and that voting process took place by email. I was not involved in that process, having been one of the nominations. I'm going to let Diane announce the Vice President and the committee members to you.
Thank you. Hopefully you can all hear me. Yeah, so our voting did take place and we received a good number of votes. Thank you for everyone. Our Vice President will be Carmen Aboy from Carmen Consulting, and the remainder of the committee is Cameron Wilson, Shepson and Wiley, Tatan Boras from Farrell Inc., Navi Green Thompson from Navy Green Thompson and Associates, Danielle Ibrahim from Norton Rose Fulbright, Klingiwe Skosana from Garlick and Bousfield, Kershia Governor from LabourNet, and Cara Barnard from ENS Africa.
Thanks, Di. We're now going to move on to, that brings the AGM to an end. We're going to move on to our presentation for today. Obviously, because we're running the AGM and also the presentation via MS Teams, questions and answers won't be something that we do live. What members can do, however, is use the Q&A function to put questions both in relation to the AGM as well as Richard Haslop's presentation, or alternatively email the questions through to Diane, and we will then collate a response that will be distributed to everyone thereafter. I'd like to now welcome our speaker, Richard Haslop, who's going to be speaking to us on pickets and polls. Richard Haslop has been an attorney since 1981 and the Employment Law Director of Woodhead Bigby Inc. since 1991. He was a member of SASLAW's KZN Committee for 16 years, on the National Committee for about a decade, and served as President of SASLAW from 2006 to 2008. He writes the Labour Dispute Resolution course notes at the School for Legal Practice, where he has lectured since 1995, is a contributing reports editor for the Industrial Law Journal, and has served as an acting judge of the Labour Court. Yet somehow he still knows more about music than labour law. So I'd like to welcome Richard. Thank you.
Hi, thanks, Carmen. Okay. Pickets, polls, and peace clauses. The point of this is issues that have arisen in strike law in the last year and a bit since there were amendments to legislation at the beginning of 2019. But before we start with that, I just want to bring something to your notice that you may not be aware of. There's a recent Constitutional Court judgment I think it was, judgment came out maybe 2 weeks ago. AMCU versus Ngululu bulk carriers. And the judgment says the following, which I'm still trying to get my head around whether it's obiter or not, because if it's obiter, we needn't worry too much, but if it's not obiter, we've got a lot to worry about. And paragraph 17 of the judgment says the following: depending on the reason for the dismissal, once conciliation fails to resolve the dispute, the affected employee has two options if she wishes to pursue the matter further. If the employee has alleged that the reason for the dismissal is one of those listed in section 1915B, then she may ask the relevant bargaining council or the CCMA to arbitrate the dispute. Now, that is completely different to the way labour law has run jurisdictionally ever since the new Labour Relations Act came into operation. The judge goes on to say that is if the body asked to arbitrate is the one that conciliated the dispute. The other option is that the employee may refer the dispute to the Labour Court. A couple of paragraphs later, the judgment says the following: if the reasons so revealed include those mentioned in section 1915B and conciliation fails, the employee has a choice to pursue arbitration or adjudication. This has been checked with the judge concerned, who has confirmed that this has been correctly transcribed. So potentially we now sit in a situation where suddenly somebody who's dismissed for striking or automatically unfairly dismissed can insist that the bargaining council or CCMA hears an arbitration about the matter. So we'll see. Should we watch this space? We'll see what happens from here. Okay, pickets, polls, and peace clauses. I was hoping that we'd have a final decision by now, but we haven't. On the question of whether a registered trade union that does not have a ballot clause in its constitution has to ballot in order for its strike to be protected. That was a question that came before the Durban Labour Court last year, twice on the same day. So the court consolidated the two matters and issued one judgment. And that was reported, you will, I think everybody's probably got a copy of this, Di? Yes, you will have a copy of my talk available. It's the case of Malabear SA Pty Limited versus NUMSA and others, and Foscorp Pty Limited versus NUMSA and others. Just a little bit of background. I acted for Malabear in the case, and we were convinced that we had good prospects of interdicting the strike as unprotected on the merits. So I considered there was talk going around labour law at the time that maybe you couldn't strike as a registered union unless you had balloted, if you didn't have a balloting provision in your constitution. And I'd considered that and decided, obviously under instructions, not to take that point because we wanted a decision on the merits, because we thought we would win on the merits, and the merits were an issue that comes up every couple of years and everybody wants to go on strike, and we thought finally the judge is going to tell the union that you can't strike over these issues. Foscor was represented by somebody else, and when we got to court, the judge raised the issue of the balloting and then postponed the matter, put an interim interdict in place and postponed the matter for argument. So we argued, obviously I argued for the strike to be held unprotected because that's what the judge wanted to hear. He didn't want to hear the merits at that point. And the strikes in both cases were interdicted as being unprotected on the basis that NUMSA had not held a ballot. NUMSA does not have a compulsory balloting provision in its constitution. And so here's the story. This is then the law. The Labour Relations Act does not require a ballot, as presumably everybody knows, to be taken before a trade union is entitled to call employees out on strike. But Section 95 deals with what must be in a trade union's constitution for a trade union to be registered. And the important clauses here are 95.5p and to a much lesser extent, in our case, 95.5q. 95.5p says the constitution of any trade union that intends to register, remember this comes from the 1995 Labour Relations Act, provide that the trade union, before calling a strike, must conduct a ballot of those of its members in respect of whom it intends to call the strike. That's if it intended to register from 1995. Q talks about not disciplining members who don't comply with a union call out to strike if there's no such provision in the Constitution. We needn't worry about that. Now, by the time the 1995 LRA came out, most of the large trade unions had already registered. This clause only applied to trade unions that intend to register. So at the time, this clause did not apply to NUMSA, being the union in our case, but apparently many, if not most, large trade unions don't have such a provision in their constitutions. However, Schedule 7 of the Labour Relations Act in 1995 had transitional provisions, and Item 5 of the transitional provisions said the following: a trade union registered or deemed to be registered in terms of the labour relations laws immediately before the commencement of this act will be deemed to be a registered trade union under this act. So let me take NUMSA again. NUMSA was already a trade union registered in terms of the prior act, so it was deemed to be a registered trade union under the 1995 legislation. Item 5 went on at sub-item 4 to say if any provision of the constitution of a trade union does not comply with the requirements of section 95, and of course theirs did not comply with the provisions of 95 because it did not have the balloting requirement, the registrar may direct that that trade union in writing to rectify its constitution and submit to the registrar within a period. It goes on to say, if the trade union fails to comply with that direction, the registrar must notify the trade union that cancellation is being considered, cancellation of its registration is being considered because of its failure. And it must give the trade union an opportunity to show cause why registration should not be cancelled. Then goes on to say that when the 30-day period expires, that's the notice period to show cause, the relevant trade union, if it has not yet shown cause why its registration should not be cancelled, the registrar must cancel the registration or take other lesser steps that are appropriate and not inconsistent with the Act. Now, at the time, and I'm talking about NUMSA because I know, but it probably applies to lots of trade unions. At the time, NUMSA's constitution did not have such a provision about balloting before a strike. It had not complied with, sorry, its constitution didn't comply with section 95. But NUMSA is still registered. So we presume that we had said the registrar may direct the trade union to rectify its constitution. He may not have done. In fact, he probably didn't. Or else he took other lesser steps, whichever those lesser steps might have been. But the point is that we get to 2019, last year, and NUMSA has a constitution that still doesn't comply with section 95. So that's the first leg in the legislative, whatever legs make up. The Labour Relations Act says the following at section 67(7). The failure by a registered trade union to comply with a provision in its constitution requiring it to conduct a ballot of those of its members in respect to whom it intends to call a strike may not give rise to or constitute a ground for any litigation that will affect the legality of the strike. So if you have a provision in your constitution as a registered trade union that says members must ballot before a strike, and you ignore that provision, the strike is not unprotected. Section 67 says that your failure to comply with your constitution does not render your strike unprotected. That section is headed strike or lockout in compliance with this act. So it apparently does not apply to a trade union that does not have a strike ballot provision. So on the face of it, that section saying the strike is not unprotected did not apply to NUMSA because it doesn't fall under the description in 67(7) which says the trade union that has failed to comply with its constitution. NUMSA didn't have it in the constitution, so they weren't failing to comply. And of course, it didn't apply apparently to an otherwise unprotected strike. 1st of January 2019, the Labour Relations Amendment Act, 8 of 2018, came into came into effect. Now that act has transitional provisions as well. It's interesting, if you try to find these, they're hard to find. I have raised this with JUTA, and apparently they're going to rectify it, but online JUTA statute has incorporated the amendments into the Labour Relations Act, but has overlooked the fact that there are also transitional provisions. So it's hard to find those transitional provisions, but this is what section 19 of the transitional provisions says. The registrar must, now you remember under section 95.5, the registrar may, that's of the LRA. Now the registrar must, within 180 days of the commencement of this act, which is the Amendment Act, in respect of registered trade unions that do not provide for a recorded and secret ballot in their constitutions. So it goes a bit further. It's not just a ballot, it's now a recorded and secret ballot. It must, A, consult with the office bearers on the most, appropriate means to amend the constitution, and B, issue a directive to those unions as to the period within which the amendment must be effected. So that's what the registrar now must do. That's within 180 days of the commencement of that act, which means by the end of June last year, the registrar was supposed to have done that. Then subsection 2 of the transitional provision says, until a registered trade union complies with the directive made in terms of subsection 1B and the requirements of section 95.5P and Q, the trade union, before engaging in a strike or lockout, must conduct a secret ballot of members. That's the section that the judge in the Durban Labour Court used to declare the Marlebear and Foscor strikes unprotected. Now, one of the obvious differences between these transitional provisions and the previous provision is that there's now a peremptory requirement on the registrar to do this. Before, registrar may require the trade union to do this, and if the trade union doesn't do it, registrar may cancel its registration, or the registrar may take other lesser steps. Now it says registrar must do that, and until they have complied with the directive and the requirements of the section, they must conduct a ballot before going on strike. So before the court comes these two cases of Marlebear and Foscor, and the judgment, in the judgment, the judge, who was Judge Gush, found that NUMSA had argued in that case that the requirement to ballot would only apply once the registrar had issued the directive. The employers, both employers, had the same argument. The employer's argument was that the section says until they've complied with the directive and the requirements of section 95.5. 95.5 says you have to have it in your constitution. You don't have it in your constitution, therefore you haven't complied, and it's irrelevant whether you've had a directive. In terms of just reading the section, you need to ballot. This, as I said, was not actually what we wanted, because we wanted a decision on the merits, which we didn't get. The judge found in his judgment, which is reported, that the provisions of section 19 are clear and unambiguous, and until the respondents comply, they may not engage in the strike. So the court interdicted the strikes pending the holding of a secret ballot by NUMSA. NUMSA took that judgment on appeal. AMCU has been admitted as an amicus curiae because it had a slightly different argument. And this appeal was to have been heard on the 27th of May, which is last week. The court, neither of the employers has opposed the appeal. The court has told the two unions that it was not going to hear oral argument, that it would decide the case on the papers. I know that at least one of those unions, because I've spoken to their legal representative, thinks that that means they're going to win. My own view is that they're going to win. One of the main reasons I didn't take the point because I didn't think it was a good point. Not only that, it also didn't serve our purposes because we still don't have an answer on the merits. But what happened after that in the two cases was that in Malabar, the union did not ballot, but the parties resolved the issues. In Foscor, the parties did not resolve the issues, so the union balloted and went back on strike. Foscor then argued its case on the merits, which were completely different, I have to say, to the Malabar merits, and lost its case, and the strike was protected. So the outcomes were quite different. I don't think it made any difference to the judgment, but when you read the judgment of Judge Gush, he appears to completely have overlooked the transitional provisions in item 5 of Schedule 7 to the LRA, because he makes a comment that it's inconceivable that a union like NUMSA would not have such a provision in its constitution because it had been registered, and it was inconceivable that it could have been registered without such a provision. He seems to have overlooked the fact that the transitional provision said that a union like that was deemed to be registered. Notwithstanding that, I don't think it makes any difference at all. A similar case came before the Labour Court earlier this year in the air chefs case, and there the court, there the union had balloted and it was NUMSA again, so NUMSA, I guess, learnt its lesson, balloted in the air chefs case, but not secretly. And the court found in that case, and that was a Johannesburg case as far as I can remember, that it had no reason to differ with Malabar. So 2 reported judgments from the Labour Court have now said the same thing. The court particularly found in the air chefs case that this limitation on striking did not erode employees' right to strike. It was purely a procedural matter. So let's look at some of the other legislative documents. There are guidelines on balloting for strikes or lockouts. Item 11 of the guidelines, which were published on the 19th of December 2018, so they were published 2 weeks before the Amendment Act came in. And item 11 says, in terms of section 19.2 of the LRA Amendment Act, until such time as a trade union or employers organization complies with the directive to change its constitution, it must conduct a secret ballot of its members. That's actually not what the section says. So the guidelines don't repeat the section. The guidelines interpret the section to leave out the bit about complying with section 95.5 of the LRA. Then, in the Code of Good Practice, Collective Bargaining, Industrial Action and Picketing, published on the same day, once again, published before the Amendment Act, but only came into operation after the Amendment Act, said, the Act does not require the conduct of a ballot as requirement for a protected strike. Now, the Labour Relations Act, that's quite right, does not require the conduct of a ballot as a requirement for a protected strike. But the Code of Good Practice doesn't even refer to the Amendment Act, although the Amendment Act was already in place. So these are the 2 sort of balancing acts. Now, it seems to me that the point of the transitional provisions is difficult to understand if the point is not to require a ballot before striking. Because if you don't require a ballot before striking, why even have that in the legislation at all? But on the other side, and this is, I think, the way the court's going to go in the appeal, if non-compliance with the requirement of a union's constitution does not affect the legality of a strike, it's not clear to me why the failure to have the provision in the constitution so that you can ignore it would affect the legality of the strike. So, for example, if the trade union could quickly enough at the time have incorporated a strike ballot into its constitution and then simply ignored its constitution, the strike would have been protected because it would then have fallen under section 67(7). So it's an odd, part of this I think is what happens when you legislate by consensus and people are giving up the wording in one clause to get the wording in a different clause, and these clauses just don't talk to each other. There's also this, non-union members, non-union workers in a workplace don't need to ballot before striking. So that seems to suggest, as has now been raised in the appeal, that this issue is actually not an issue between the employer and the employee. This is actually an issue between the union and its members. That members must be able to hold the union to a ballot, but employers can't. That's one of the arguments. Because non-unionized people don't have to ballot. So it's not about you can't strike without a ballot. That's one of the arguments. So heads of argument, this is what the Labour Appeal Court is now deciding on. The heads of argument for NUMSA have argued that the Malabé decision is wrong for the following 4 reasons. Firstly, the language of the Amendment Act suggests that your obligation only arises once the registrar has issued a directive. Remember that it said issues a directive and you must have complied with the directive and complied with section 95(5), otherwise you have to ballot. They're saying that the only way to interpret that, and I don't believe it's the only way to interpret that because it's not the way that 2 judges have interpreted it, but they are saying the only way to interpret that is there must be a directive, otherwise the section doesn't apply. The second point on appeal from NUMSA is the amendment has to be interpreted together with section 67(7), which says that if you ignore your constitution, it doesn't affect the legality of the strike. The third point is that the purpose is not to permit employers to interdict strike action, but to provide that the ballot must be a secret ballot, and that is an issue between members and union, not between union and employer. And then finally, the amendment was not introduced, well, it's really the same point put differently. Not introduced for the benefit of employers seeking to prohibit strike action. It refers to the relationship between the union and its members. That's NUMSA's case on appeal. AMCU, the essence of AMCU's argument is that Section 19 of the Amendment Act has to be interpreted so that it does not limit a right contained in the Bill of Rights, such as the right to strike. And the famous case of McCarthy and Vodacom is what it has referred to. So in line with that interpretation, a trade union does not have to ballot until the Registrar of Labour Relations has both consulted with the union leadership and thereafter issued the necessary directive. That's the first thing, and that hasn't happened. Excuse me. Secondly, the injunction to trade unions is not to amend their constitutions so as to comply with Section 95, but to comply with the registrar's directive. They say that's how the section must be interpreted. And once again, you can't comply with the directive until there is a directive. They've pointed out that in terms of Section 101 of the Labour Relations Act, a trade union cannot simply unilaterally amend its constitution. There's a process, quite a rigmarole, in fact, that goes through the registrar to amend your constitution. So it's not just a case of you better stick this in your constitution if you want to go on strike. And then there was a directive, it seems, purportedly issued by the registrar on the 1st of March 2019, but it seems that that was A, not received either by NUMSA or AMCU, and who knows, not received by whoever else. And B, was in any event defective. And in any event, they say no one's consulted with the union leadership. So AMCU has based their case excuse me, purely on interpretation of the Amendment Act. And they're saying you can't amend, you can't interpret the Amendment Act so as to limit the right to strike, because the Act itself doesn't limit the right to strike. In their argument, they've argued, and I just think they're wrong here, but it doesn't really matter because they're wrong on the facts. They've argued that the court in Malabé incorrectly assumed that the registrar had issued a valid directive. Actually, that's not so. The judge doesn't assume that at all. Neither of the parties was of the view that the valid directive had been issued. In fact, I think it was common cause between the parties that A, NUMSA did not have such provision in their constitution, and B, no valid directive had been issued. So I don't think the judge incorrectly assumed anything. What the judge did was he interpreted Section 19 in a different way. So clearly there's need for an appeal here, and maybe ultimately even the Constitutional Court, because the courts are reluctant to read additional limitations into the right to strike. And you would have thought that if, well, one would have thought that if the intention of the amendment was to limit the right to strike, that would have amended Section 64, which is where the procedural requirements for the protected strike are found. So very simple, simply to amend Section 64 by saying that if you're a trade union that has not done whatever you're supposed to do, you may not go on strike. Same as if you haven't referred the dispute, or you don't have a certificate, or you haven't given the notice. So we wait to hear what the LAC is about to say. They might even be thinking about it as we speak. The second issue here, and this was really the issue that was at stake for Malabé, was the issue of the peace clauses. And we never got an answer on this, but I think ultimately judgments have gone in our favour and we should be okay. Section 65(1)(a) of the LRA prohibits participation in a strike where the strikers are bound by a collective agreement that prohibits a strike in respect of the issue in dispute. So that's 65(1)(a). You're bound by a collective agreement that prohibits a strike. 65(3)(a) prohibits participation in a strike where strikers are bound by a collective agreement that regulates the issue in dispute. So that's the distinction between 65(1) and 65(3). 65(1) is you're bound by a collective agreement that prohibits a strike, and 65(3) you're bound by a collective agreement that regulates the issue. So one of the questions here that we had thought of trying to get resolved but didn't get that far was whether, because here there was an issue of interpretation concerning the Motor Industry Bargaining Council main collective agreement and what was allowed and what was not allowed as far as strikes were concerned. And one of the questions that I had raised notionally, although we didn't actually go and do this, but it was a notional thing and I still don't know the answer to it, is whether if you refer that agreement to an interpretation arbitration under Section 24 and you get an arbitration award saying that the meaning of that section is that you can't strike over that issue, and then there's an attempt to strike, and then you go to the Labour Court to interdict the strike, do you have a clear right, because you've got an arbitration award in your favour, even if the judge disagrees with the award? That's really the question. If the award has not been overturned or set aside on review, then it is possible that an arbitrator thinks that the collective agreement means A and you can't strike, and says so in an arbitration award. And you go to court to interdict the strike, and the judge, is he bound by that arbitration award, even if he thinks you don't have a clear right? My view is you probably do have a clear right, but it's It's one of the issues that I'd hoped might be resolved in this particular strike and wasn't. So now, many collective agreements contain peace clauses, so I'm using the motor industry main agreement, which is still, I think, in a bit of a mess. So I'm using the one that's still on their website, which is the one that expired on the 31st of August last year. And I do have a long story from the council about where they are with the agreement and who's signed it and who's refused to sign it and where the minister's, what the minister's doing about extending it and nothing. So it appears to me that there is currently no valid motor industry main agreement for the industry. There may be individual parties that are bound. Okay, so and I'm told, by the way, that the one that's in the pipeline is not very different from the one that's on the website. So let's go with the one on the website. Clause 4.1 of the preamble provides there will be no participation in any form of industrial action as a result of any dispute on wage and/or salary adjustments and other conditions of employment. It goes on to specifically say that participation in any form of industrial action during the life of the agreement is unprotected. So there's your collective agreement that prohibits a strike in respect of particular issues. It's important to note that these issues under clause 4.1 are disputes over wage or salary adjustments and other conditions of employment. Now, in the way of bargaining council agreements, the rest of the preamble doesn't agree with that. Clause 2 of the preamble provides that bargaining in the industry takes place at centralized level and states that, with one exception which doesn't apply to most people, there shall be no two-tier bargaining on any matter of mutual interest. That provision is repeated in clause 4.2. So 4.1 says no strikes over wage or salary disputes or other conditions of employment, and any industrial action is unprotected. 4.2 says no two-tier bargaining on any matter of mutual interest, which is a whole lot wider than conditions of employment. So one of the issues is, how does industrial action take place without bargaining? So does that not then effectively bar strikes anyway? Secondly, the concept of matters of mutual interest has been, as you will know, extremely widely interpreted by the labour courts in order to broaden the right to strike. The irony here is that using the same wide interpretation, if you've got a collective agreement that prohibits strikes over matters of mutual interest, well, then you must presumably use the same broad interpretation, and then it reduces or limits the right to strike more than maybe was intended. So, and then of course there's the problem with the phrase two-tier bargaining, which they year in and year out keep using, and it doesn't exist in any legal framework in South Africa. Internationally, two-tier bargaining has two completely different meanings, potentially. The one is no bargaining at a lower level than centrally at all. The other one is no bargaining at a lower level over any issue that has been bargained centrally. Two completely different concepts. If you want to limit the right to strike as little as possible, you go with the second of those. So only if the issue has been bargained centrally are you prohibited from two-tier bargaining it. There have been a number of judgments about this. Vanachem Vanadium Products said that an allowance, there was a collective agreement providing for an allowance to employees who are required to work away but not live away from their usual place of residence. And that was closely related to a demand for the payment of travelling costs, so that the strike was prohibited over a demand for travelling costs. In air chefs, this is a different air chefs to the one I referred to earlier. Same company, different judgment, different union, in fact. That the only forum for the negotiation of substantive conditions of employment was the bargaining council. That's what the main agreement says, and therefore the demand in question, which did relate to substantive conditions of employment, was not a demand that the union could strike over, because the main agreement said the only forum is the bargaining council. In the Yarntex case, the Textile Bargaining Council collective agreement did not specifically prohibit strikes at plant level, but prohibited plant level bargaining over wages and conditions of employment. And once again, the court found that and this is the Labour Appeal Court, that the prohibition on bargaining means a prohibition on striking over those issues. So Unitrans, you can read it, it's not very different. Harmony Gold Mining, same thing. In all of these, the strike was declared unprotected, even though it wasn't specific to the wording of a bargaining council agreement or any collective agreement. Imperial Cargo is a recent case, that here there's a collective agreement that prohibited a strike over substantive issues. Substantive issues meant all issues involving cost and affecting the wage packet of employees. Here, the Labour Appeal Court found that the demand to reschedule the trips of drivers was an impermissible demand as far as striking is concerned, because the rescheduling of the trips would have an effect on overtime pay and weekend pay, and those affected the pay packets of employees, and therefore they were substantive issues, and the strike was therefore unprotected. Or would have been, it hadn't yet taken place, but the strike would have been unprotected. And then this is one that presumably is dear to the motor industry's heart. The Wallenius Wilhelmsen Logistics case, where the Labour Appeal Court has found that what happened here was the previous Motor Industry Bargaining Council agreement lapsed, just as the current one has lapsed. And in the lapse period, where there is no current collective agreement, main collective agreement in place, this company's employees had demanded increased transport allowances. And the argument was, we're not bound by a collective agreement, there is no collective agreement. And the answer of the Labour Appeal Court says, firstly, this is essentially a demand for a wage increase, because you're not asking for the reimbursement of transport costs. You're asking for an allowance. And the MIBCO constitution says, or is a collective agreement, and the MIBCO constitution has not lapsed, it overrides all of this. And that requires any matter of mutual interest to be negotiated at MIBCO level and not at plant level. And therefore, once again, if you're not allowed to bargain over the issue, it seems to me, in terms of this judgment, you're not allowed to strike over the issue. This was exactly the answer we were looking for from our Malabert case that we didn't get because NUMSA hadn't balloted. In fact, I wish they had balloted, because then we would have had an answer. In the Foscor case, though, where the balloting didn't take place, they had a completely different outcome. So what happened there, they got an interim interdict, they balloted. They didn't resolve their issue. The company went back to court to prohibit the strike and lost. And the strike was declared protected. In that case, the demand was for an ex gratia payment of 25,000 Rand for each employee who would otherwise have benefited from the success of a share incentive scheme that had failed. So they were party to a share incentive scheme, the scheme failed, and so they didn't get any money, any extra money from the share incentives. They demanded an ex gratia payment. The parties were bound by an still existing collective agreement that had been entered into with a previous majority union. So they were still bound by a collective agreement, and that agreement had made provision for certain increases in respect of wages and certain benefits, and further stipulated that all other pre-existing terms and conditions of employment would remain unaltered. They were bound by that agreement. And the court found that because the ex gratia payment was not one of the benefits mentioned, the strike was not prohibited. The court completely overlooked the catch-all phrase that said all pre-existing conditions would remain in place, which bound everybody. Unfortunately, and it wasn't, it was a different judge by the time it came back to the Durban court. So it wasn't Judge Gush, but unfortunately there was no written judgment. It was an extempore judgment. So it seems to fly in the face of everything I've said so far, though. Do I have time still? 5 minutes. Let's just talk quickly about picketing, because it struck me at the time, because we had picketing issues at the strike as well, and we had new picketing legislation, and it struck me at the time, because you only really see these things when they happen, that there's quite a lot in the picketing legislation that leaves a bit to be desired. So in terms of the amendments to Section 69, which came into operation last year, the Commissioner conciliating the dispute must, in the absence of a binding collective agreement regulating picketing, attempt to secure an agreement between the parties on picketing rules before the expiry of the period mentioned in 64(1)(a)(2). That's 30 days or extended period by agreement. In other words, before the certificate of outcome is issued, the Commissioner conciliating the dispute must try to secure an agreement. In the absence of an agreement, the Commissioner conciliating the dispute must determine picketing rules at the same time as the certificate of outcome is issued. I've come across a lot of strike matters. I don't know if this has been improved recently, but certainly last year, a lot of strike matters where the certificate of outcome was issued without strike rules. And that's peremptory, must at the same time issue picketing rules. No picket may take place in the absence of picketing rules that are either contained in a binding collective agreement or have been agreed between the parties or have been determined by the Commissioner. So no picketing without the rules. No certificate of outcome without the rules. And yet somehow there were strikes all over the place that didn't have certificates, that had certificates of outcome, so the strike's protected, but the picketing is unprotected because there are no rules. In terms of Section 69(8), disputes concerning the following must pass through conciliation, and conciliation is by the CCMA, not by a bargaining council, on the way to adjudication by the Labour Court. These disputes go to the Labour Court via the CCMA only. An allegation that the effective use of the right to picket is being undermined, an alleged material contravention of 69(1) or 2, which are the right to picket or the location of the picket, a material breach of a collective agreement or a picketing agreement secured by the Commissioner, or an alleged material breach of a picketing rule determined by the Commissioner. So those disputes go to the Labour Court via the CCMA. But now what happens when no picketing rules? The Labour Court has described picketing rules as an essential and an integral part of a protected strike. What happens when no picketing rules are in place, even though the strike is protected? Presumably the employer's recourse is then to approach the Labour Court directly on an urgent basis, because it doesn't fall under those disputes that are required to go via conciliation. This scenario might also arise where the conciliation does not take place within 30 days and no certificate is issued, but the union is then entitled to go on strike after notice. So what happens there? That's not been covered by the section that requires you to go to conciliation. There was a case just before the amendments came to operation, Dis-Chem Pharmacies, where the Labour Court confirmed that it had the power to suspend a picket where the strikers' conduct constituted violation of their right to peaceful protest. But now Section 69(12) specifically empowers the court to suspend a picket at one or more of the locations designated in the collective agreement, agreed rules, or rules determined by the Commission with a capital C. So when can the court suspend a picket? It can suspend a picket when there are agreed rules or a collective agreement or rules determined by the Commission. So what if there aren't rules determined by the Commission? What then? Because the Commission doesn't include a bargaining council. And yet, the Commissioner conciliating the dispute, by definition, includes a person appointed by a bargaining council to conciliate a dispute. So once again, the sections seem to be thrown together without reference to each other. So there are all sorts of potential places where you could drive trucks through the picketing legislation, I believe. I think ultimately sense will probably prevail, even if there were no amendments. But I particularly mention this because Section 69(6) capital B specifically refers to rules determined by the Commission as being different from rules determined by the Commissioner conciliating the dispute, because there are circumstances where the CCMA itself may establish picketing rules rather than the Commissioner conciliating the dispute. So once again, you can suspend a picket if they're not complying with rules determined by the Commission, but what if they weren't determined by the Commission? What if they were determined by the Commissioner conciliating the dispute and he came from a bargaining council? Thank you. That's all I have to say.
Thank you, Richard, for availing yourself to address us this afternoon. That was very informative. We'd also like to thank Woody at Bigby for allowing us to host the AGM from its premises this afternoon. Thank you, ladies and gentlemen, for your time.